What are the two words that insurance companies fear and drives them to make a fair offer in your wrongful death case? If you are the administrator of the estate of a loved one, a family member who was tragically killed because of somebody else's fault, what would drive the insurance companies to make you a very fair offer to resolve the case? My name is Bernie Tully, incidentally, from the Tully & Tully Law Firm at 412-281-8700. The two words are, quite honestly, simple: bad faith. If we are able to establish that the insurance company for the person who tragically killed your loved one was acting in bad faith, or is acting in bad faith at the present time in terms of a lowball offer, an offer that is unreasonable, things like that, then you can claim bad faith. Now, why is that those two words sort of magical? Well, here's what it is. Bad faith is excess money in addition to the amount that you're entitled to for the deceased member who tragically was killed, for their earning capacity, loss of earning capacity, for their medical bills, for their funeral expenses, for the pecuniary interest of losing a loved one, the emotional impact. Those are all items that you can list on a paper and add them up, and that's the total amount for the wrongful death. But if we can establish that the insurance company is acting in bad faith, then we can say on top of that, as punishment, they call it punitive damages in the law, as punishment for the way the insurance companies are acting or the defendant acted, you can get more money to tack on to your regular damages. And the other good thing about the bad faith, if you can establish it, is that the sky's the limit. Essentially, it's what a jury thinks is fair to punish the wrongdoer and to stop them from acting in the way they were in your case. And usually what happens in these, how do you establish or how do you find bad faith for a defendant? Because that's sort of like the holy grail, is this. If the defendant and the insurance company who represents the defendant and has the money, if they acted and were given notice of a condition and they didn't do nothing about it, they just let it ride, let it sit, didn't do anything to remedy the situation, then you can allege bad faith on top of the normal damages that we talked about. Let me give you an example. If you're suing the government, a municipality, for the death of your loved one, and there were 57 recorded complaints of an intersection being dangerous and causing accidents, and that happened 57 times at that same intersection within a couple year period, then you have the right, under circumstances, suppose again there's a trucking company involved and things like that, to not only go after the government, but then to go after the trucking company, and in there to allege that the government acted in bad faith. And if the government is insured, there's a case right now up on whether the cap should be lifted from what they currently are, then you can make that allegation. And you can see how that would get an insurance company very nervous about it. This often happens even more appropriately if it's a private insurance company, General Accident, Nationwide, any of these, and you can establish bad faith. Then they want to talk. I've been doing this for 40 years. My name is Bernie Tully from the Tully & Tully Law Firm, 281-8700. Give us a call. We know we can help. We'll at least listen to anything you can provide us, and we can tell you up front whether we can help you or not. Tully and Tully Law Firm. We travel all throughout Pennsylvania.